Hey guys, in this one, we're going to talk about 7 ways that your U.S. citizen child can help you to get a lawful status or to stay in the United States. For those of you who are new to me, welcome to my channel. Welcome to this video. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients all over the world on complex family and business and removal immigration matters. Reach out to us at 516-866-3900 to request a consultation with an attorney if you are looking to hire an attorney at this time. Okay, so let's talk about this. I get this question a lot. You know, I have a 2-year-old child or a 5-year-old child, U.S. citizen. What can be done for me if, since I have this child? Well, here are 7 things that I want you to think about, okay? If you're a parent of a U.S. citizen child. The first way that that child can help you is if that child is at least 21 years old and a U.S. citizen. That child could obviously file for you for a green card. If you're here in the United States, you would go through a process known as adjustment of status so that you could get your green card right here in the United States. However, if you had entered without inspection or you cannot prove lawful admission or inspection or you're outside of the United States, you will go through a consular process abroad at a U.S. embassy where you're going to be interviewed for the immigrant visa, and then you'll come into the United States. So that's one obvious way that the child could help you. Now, the second way that they could help you is if you're in removal proceedings, deportation proceedings, you can apply for cancellation of removal if you're eligible for it. Guys, cancellation of removal is very complex. You need to have, I would highly recommend that you have professional help with this if you're in removal. It's not available to everyone in removal. Only certain people are eligible for this. But if you're eligible for cancellation of removal, a child who is under 21 and unmarried, U.S. citizen or green card holder child, can help you if you could show the judge some very strong sympathetic factors related to that child and why you need to be here in the United States for the sake of this child, okay? The third way that a child could help you, also if you're in removal, is by being considered for a waiver for fraud or misrepresentation. If you have been charged with fraud or misrepresentation related to your immigrant visa, your admission into the United States, or even your green card, you could apply for you could not apply, but you could ask for this waiver in court, and the judge can consider it if you have a U.S. citizen child of any age. This waiver is different from another form of waiver that you guys may have heard me talk about before, which is the I-601 waiver to waive inadmissibility problems like fraud or misrepresentation. But that waiver goes to USCIS, and you cannot use a child for that. You could only use a spouse or a parent who is a U.S. citizen or a green card holder. So just understand that there is a big difference here between those 2 types of waivers. Fourthly, a child can help you go through an immigration humanitarian process known as humanitarian parole. And this is for those who are outside of America and as well as those inside of America who have some strong humanitarian reasons why they should have a temporary lawful status here in the United States. Perhaps because of this child and some of the things that this child is going through, medically speaking or otherwise. You could use the child as a factor in your argument why you should be allowed to get this humanitarian parole. The 5th way is also kind of similar to that, but the procedures are different, but it's known as medical deferred action. And for this one, you've got to have some serious medical condition going on with the child, like maybe Down syndrome, autism, or other serious conditions, and you're asking that ICE does not take any action to remove you from the United States during this 2-year period that you've been granted this status. Now, this status does not lead to a green card, and it is very temporary, okay? Very temporary, although you can apply for another one. at the end of the 2-year period. But just know that it also comes with a not the green card, it comes with an EAD. Okay, so that's a major benefit with this one. You can get a work permit. Now, the sixth way that a child could help you is if you had gone through the removal process and the judge issued a removal order against you. Maybe you had appealed the decision and it was denied. And now you're desperate. You've basically exhausted pretty much all of your remedies, so to speak. You could apply for a stay of removal to either the Board of Immigration Appeals, federal court, or even to ICE. And through, a child, you could argue that, I have a young child here, or, U.S. citizen child, and that could be considered as one of the factors to grant you stay of removal, which, by the way, if you are granted stay of removal, you would be eligible for a work permit as well. Okay. And then the last way that I could think of at this time, I'm sure there might be other ways, of course, but the seventh way is I've seen how having a U.S. citizen child can help a parent who has been temporarily detained by ICE. For example, if ICE shows up at your house, arrests you, detain you that day, bring you down to their office, the fact that maybe you're the only guardian for this child or children, I've seen how ICE releases these parents same day. Okay, so I've seen how it helps the parents get out of detention faster and get to stay here longer. So anyway, friends, those are just 7 ways that a U.S. citizen child can help their parent as the parent is here in unlawful status. I hope you found this helpful. Share it with other people. Subscribe to my channel, McBean Immigration TV. Hit the notification bell so that you'll get awareness of my videos each week.